supplied the court, and I've supplied counsel.
Or a court's exhibit, I guess.
A court's exhibit.
Court's exhibit.
Not a trial exhibit, this is.
Right,
not a trial
right.
exhibit.
That way there's no chance of confusion. Court's, I'll receive it as a court's exhibit.
And I'll be number 40.
Session out of the presence of the jury. Mr. Durst is present with Mr. DeGuerin and Mr. Chesnoff, and we have Mr. Lewin and his team present. Mr. DeGuerin, you sent me a medical report from the Mr. Durst doctor, and you wish to be heard regarding that.
Thank you, Your Honor. Yes, I do. I have marked as a court's exhibit, I think exhibit 4 for the record, not for the jury, a report from Dr. Keith Klein.
Not for the jury. Sorry.
And I had emailed it to the court and to counsel earlier. What I hold in my hand is a printout of the records we received yesterday, almost 500 pages, of his recent hospitalization. First, what they confirm is that contrary to Mr. Lewin's assertions about suspicion of faking his conditions, his condition has been confirmed exactly as Dr. Klein reported to the court some time ago. He has a very severe medical condition. What that concerns us about, first and foremost, of course, is Mr. Durst's very survival, his health, and how the rigors of having to come to trial while he's suffering these conditions affects his health and could very well kill him. Our other concerns are twofold. One, his ability to assist in his own defense is severely impacted by his condition. And secondly, that affects our ability, the lawyers, our ability to provide him assistance of counsel as his constitutional guarantee. I might simply reiterate what's in the 3-page report from Dr. Klein and in the 500 pages of medical records, many of which are redundant, but certainly are observable, objective symptoms, signs, conditions of a serious condition. They show a new hydronephrosis, swelling of the kidneys from significant obstruction with urethral dilatation. When he was catheterized, and he is currently still catheterized, they voided 1,100 cc's of urine, a massive amount. He remains catheterized, and although the treatment was begun with antibiotics, he had a predictable and predicted infection in the urine and bloodstream. That's the sepsis part of the urinary tract infection. This condition is a prescription, as Dr. Klein says, end-stage renal disease and need for dialysis. He also had chest pain with palpitations. I reported that to you yesterday. And he was admitted to the medical intensive care unit on the 10th. He had an episode of ventricular tachycardia, which Dr. Klein had noted previously. He was scheduled to have a nuclear cardiology test, but did not have it. And Dr. Klein says there is no reason that monitoring should not have been done. The admitting doctor at LA County USC Hospital described him as an ill-appearing cachectic male. Cachectic means a dying person. Dr. Klein said he got the impression that the overriding concern with the discharging doctor was to get Mr. Durst back to Twin Towers and to court, and not to take care of his health. He has a cardiology follow-up, but it's now June the 22nd, which is a court day. He has a pulmonary follow-up in July, and the renal follow-up is scheduled 5 months from now. He needs it today. He needs it now. He's, again, his treatment for bladder cancer has been interrupted. He has a urethral stent. The status was not clear from the records of his examination. He has a massive kidney stone, which presents a significant risk to his life. He's malnourished. He needs intravenous nutrition for several months, and even that may prove futile. Again, Dr. Klein states that Mr. Durst cannot undergo a trial without serious risk to his health and probably to his life. This clearly interferes with our ability to consult with and to represent Mr. Durst and his ability to assist in his own defense. Any doctor would say that a catheter placement should not be, that the patient should not be traveling. The catheter placement is a serious matter. Yesterday, I think Mr. Durst held up the catheter bag, which I'm now told that's a very dangerous thing to do. He held it up to display it, I believe, to the court. And what that causes is plain gravity will cause the urine to travel back into the body and increases chances for sepsis.
I understand that's going to be removed tomorrow?
I don't know. That's not what this says. This says it was scheduled to be removed.
The report is different from what I heard this morning.
Well, the removal of a catheter is not a simple process, Judge. You don't just jerk it out and then let him go on his way. The chance of infection from a urethral catheterization is very high. And it should be done in a hospital setting only. He needs to be hospitalized, it's a simple thing. And it's not, as Mr. Lewin has suspected and stated his suspicion openly and on the record, faking. This is observations of objective symptoms by doctors at USC. Immediately before he was discharged from USC, the discharging doctor had 3 separate intravenous placements removed. One of them has become infected, and he has an infection on his right wrist right now. So what you're saying, Your Honor, is that having Mr. Durst here and go through this trial is a serious risk to his health and even his life. We need to stop this.
Will you care to reply succinctly?
And
I'm sorry, Your
so I make sure that I've said this properly. We renew the motion for mistrial. In the alternative, we renew the motion to postpone the case pending his hospitalization and recovery, if that can happen.
First of all, Your Honor, let's look at what we've got. I did not in any way, say that this was not an actual medical event. What I said was Mr. Durst has a documented history of explaining how he is going to malinger and fake dementia and how he's going to use COVID-19 to get a mistrial. That is not speculation. That's not an opinion. That's a fact. Number two, Mr. DeGuerin sends an email saying that Mr. Durst is in, quote, grave condition. Let's look at what grave condition means. Grave condition is beyond critical condition. Critical condition basically means that you are in such severe condition that without immediate intensive efforts, you will not survive. Critical means that you are likely to survive with those efforts. Grave condition means you are not expected to survive no matter what is done. So we've already got hyperbole going on. He is not in grave condition. He is not in critical condition. Let's look at the condition that he's in. First of all, it was the county and their very good doctors who diagnosed this condition, got him in, got him catheterized. Now, did not think that in any way, shape, or form I would be saying the following in an open courtroom, but I'm going to because I think it's important. First of all, getting catheterized is no fun. I myself had a catheter for an entire week going in and out of court. It was not pleasant. I, in fact, recognized had the same size one Mr. Durst has, which was under my clothes. It was not comfortable, not a situation I would agree with. Regarding the idea that somehow having a catheter removal needs to be done in a hospital, I removed my catheter myself on 2 different occasions. So the idea, I'm not going to show you, the court appeared to be, I'm not going any further than that. I'm merely saying that the arguments that counsel is making go to what we know is their point. Their point is they want a mistrial no matter what, no matter how they can get it, no matter what arguments they have to make, and they've done it now, Your Honor, 60 times. So now let's look at what his current condition is. They said yesterday he was septic. That is not correct. I spoke to the attorney this morning because we have HIPAA releases and we've been given these medical records. Mr. Durst is not currently septic. If he was currently septic, he would be in the hospital. The doctors at County USC have done a very good job with Mr. Durst. And again, the fact that Mr. Durst has the ability to hire all kinds of professional witnesses, which is what Dr. Klein is, to come in and say that, you know what, he could get better treatment elsewhere, well, that's probably true. And before he decided to kill 3 people, that would have been an option for him. Unfortunately, he's charged with a capital crime where he does not have bail available to him, and he is getting better treatment than not only any other inmate at the County USC facility. I mean, he is basically, Your Honor, he is a VIP who is reviewed constantly, he's rounded constantly, but he's actually getting better care than anybody walking into the county hospital who is not in custody would be getting. So here's where we sit. Despite the statements by counsel, and one of them is he needs dialysis immediately. That is absolutely untrue. What the doctor has said is that, quote, in essence, if he continues on his current path, he cannot rule out dialysis having to occur, and I believe his original report said 1 to 2 years. But again, what they've done is they look at his condition, and they then try to make every argument they can saying he cannot go through this. By the way, every time they say he cannot go through this, we continue to go on. And I would add that Mr. Durst was supposedly going to die 20 years ago when he had the cancer the first time. So the bottom line to this, Your Honor, is they'll do anything they can do to secure a mistrial and an adjournment. A mistrial is inappropriate. An adjournment is inappropriate. This trial needs to happen. Mr. Durst needs to be held accountable for what he's done. And the idea that apparently he is not going to be in a position to assist with his defense. Let me add something else. There was a 14-month delay of this trial. I am given, and I have access to, the records that indicate how many times, I don't get to know what was said, but I get to know how many times people are meeting with Mr. Durst, when those meetings occur, et cetera. So when we have a situation where the defense is basically saying we're not having the opportunity, they're going home every weekend. My understanding is every week they leave. They leave on Thursday, they fly where they're going to fly. No one is sitting here talking to Mr. Durst. No one's making efforts to meet with him over the weekend. So the idea that they're going to now say that Mr. Durst's condition prevents them from communicating with their client, et cetera, is disingenuous at best. This trial needs to happen now.
All right, thank you. Briefly, because the juror's waiting. Go ahead. You may respond.
Mr. Lewin accuses me of exaggerating. I have done nothing but quote from Dr. Klein and from his review of the records. The fact is that Mr. Durst is a very ill person. The fact is that it does interfere currently with his abilities to assist in his defense and our ability to provide him a defense. Mr. Lewin raises hyperbole, the fact that he's charged with murder and is on trial for murder. That's true, of course. And Mr. Lewin says that he's getting better care than anybody. There's no evidence that he's getting better care or that he's treated any differently. There's no evidence of that. And as far as our ability to consult with Mr. Durst, for the past 14 months, the jail has been shut down, and face-to-face communication is extremely limited. In the largest jail system in the United States, there is one room available for contact visits, and it is reserved months ahead of time. That's so the ease with which a person is consulted is not present here as it would be under ordinary circumstances. We, in addition to that, the only visitation that's been available for months has been Wednesday, Thursday, and Friday, and then not face-to-face. That's the only visitation that's been possible. There's been no weekend visitation at all. So Mr. Lewin is incorrect about that. This is a serious matter, Your Honor. We're not exaggerating. Dr. Klein is a highly respected clinical specialist and professor. And I might say that the findings, the objective findings in this 500-page record confirm Dr. Klein's findings.
All right, first of all, thank you. I must note that oral claims and claims without notice are difficult to refute, so I must view them skeptically. That's why the California Rules of Court and LA County rules provide as follows. Motions to continue, which would include a motion to adjourn, must be in writing. That's the Los Angeles County Rule of Court, Rule 8.7a. And untimely or oral motions are presumed meritless. That's California Rules of Court 4.111b. I will say that I'll comment on what's been presented. I do not see impairment of the work of the 4 expert lawyers who have had 5 years with Mr. Durst to prepare for every contingency. As far as the doctor's report, he has a duty to his patient. I understand that we're in circumstances that are far from ideal for a sick person, all right? And Mr. Durst is a human being. I am a human being. I am not callous. It is not easy for me to require him to endure any pain. But I am guided by People versus Avila, 117 Cal App 4th 771, 778, which provided where the defendant suffers from a chronic condition causing pain and associated symptoms, the trial court is not obligated to suspend criminal proceedings. Rather, the proceedings are to be conducted in a manner that reasonably accommodates the special needs of the accused, to the extent that this is practicable in light of courtroom security considerations and other legitimate constraints. The court stated adoption of the defendant's position renders individuals suffering from chronic ailments or painful infirmities essentially immune from criminal prosecution. This would be untenable. So let me say that motions to continue are disfavored without an affirmative proof in open court that the interests of justice require the delay. That's 4.113 California Rules of Court. I do have hearsay statements before me. That's not proof in open court. I've said before, you want to schedule a hearing, I will have a hearing, I'll hear from the doctor, and you can make the case that you want to make. But based on what I have now and what I know, there is not a legal basis for any mistrial, nor is there a basis to adjourn the case. Mr. Durst is present. He has been approved by medical personnel to come to court. That means the situation is not so critical or grave that he cannot be present to hear testimony today, which I understand is all recorded. So no live witnesses today, right?
No, there are two live witnesses today that are prior consistent statements. I should add, Your Honor, because I don't know if the record reflects this, Mr. Durst yesterday was taking an abundance of notes, communicating regularly with his lawyer, was very engaged.
Yes, I saw that. I saw it. It's not even close to being.
No, I know you saw it and I saw it, Your Honor. I just wanted to make sure the record reflected that.
Yeah.
We have two witnesses that are very brief. They are prior consistent statements going to Lynda Obst. I've already discussed with Mr. Lewis. They should be very quick, both of them.
All right. Yes, Mr. Chesnoff.
Yeah, just
Something
as far
else?
as communication with our client, we do get notes from him, but I can tell you that in my entire history of practice, I've never been in a situation where I'm not able to directly communicate with my client on a regular basis. First of all, half the time I can't sit next to him because we're still under the COVID protocols. But I don't want anybody to think, for the record, that our ability to communicate is the same as it is in a normal setting with a patient distinguishable from the defendant in the case the court cited, whose condition was chronic, but whose condition was not described as life-threatening. Our position is, Your Honor, based on the records and Dr. Klein, that the continuation of the trial is shortening the time for his life. That needs to be clear. We understand Mr. Lewin's desire to complete a case. We don't feel the same way that he does about the outcome. And when we make motions for mistrial, as the court has observed on multiple occasions, lawyers have an obligation to seek a mistrial based on a legal issue that the lawyers see as being unfair and affecting the fairness of the trial. Nobody has made a single motion for mistrial, not in good faith. And the COVID motion for mistrial, which Mr. Lewin references Mr. Durst talking about, was based on a long American history of not resuming trials with the same jury after delays. That was the legal basis for it. We felt that, I know the court knows we did it all in good faith.
I'm not criticizing you for that. Go ahead. I'm not criticizing you at all. I'm just denying your motion.
Thank you. I just get tired of hearing that we're doing it as some ploy.
Okay, yes.
Not a ploy.
Mr. DeGuerin, one more thing.
2 points, Your Honor.
Yes.
First, Avila is clearly distinguishable on its facts.
You have a
Avila
different case?
suffered.
You have a different case? I don't know, show me some other authority. I'm happy to look at it. You gave me a federal case from New York where a district judge gave his reasons why you would continue a case when a person is ill, the things that he thought about. It's not authority here. It may be persuasive, but I have authority that controls my situation, and you've given me no other authority.
Avila is distinguishable on its facts, Your Honor. Avila had chronic headaches that went way back. That's a very minor thing in comparison to the panoply of conditions that Mr. Durst suffers from. That's one. Secondly, may we schedule a hearing
Yeah.
today, since we're adjourning early because of a
Yes.
juror problem.
Yes, yes, that's fine, good.
I'll need to get on the phone to see if we can have Dr. Klein here.
That's not proper notice. We need to, if this is a hearing, I assume this is a hearing that involves the prosecution as well. They can't simply tell us at 9:30, we're going to do a hearing at 3 o'clock when we are not in a position to, this needs to be scheduled in advance, as the court said, so that both sides have the ability to address the issues coherently.
I'll think about that. I certainly wouldn't require you to proceed with a cross-examination without preparation, so fair enough. It may be, so I'll think about
Okay.
that some more, and I'm open to additional suggestions. So our jurors are probably ready, shall we?
Finally, Judge,
Yes.
in response to the court's statement that what you have only is hearsay, that is the report of the doctor who's reviewed the record, I'd like to mark and introduce for the court, for the record, the some 500 pages of actual records from the doctors. And I'd like to mark that as next, court's
So
next.
we'll call it a
Be a court's exhibit.
I'm not sure that's going to satisfy the hearsay exception, but that's okay. We'll accept it.
What number?
5.
And I assume at this point in time, Your Honor, you're just marking it. We don't need to make arguments about admissibility.
Right.
Thank you.
But that is addressing my requirement, or not my requirement, but following the California Rules of Court, that motions to continue are disfavored without affirmative proof in open court, that the interests of justice require the delay, and that will require admissible evidence. So at the hearing, in open court, I would hear whether that.
And I assume, Your Honor, the court's also waiving, there's a rule of court, not sure if it's that rule of court or another rule of court that requires, if you cannot file with appropriate notice, you need to file a motion that in essence says that you are filing because you do not have time to give the proper notice. They also have not filed that as well. This has been an issue the court has repeatedly advised them about, but same.
Thank you. All right, let's prepare for our jurors.